Okay, thank you very much. We're going to go ahead and get started because Judge Shepard has a lot that he's going to cover today. Before he does, a little bit of housekeeping for anybody who has not yet ordered lunch. Please take form and show hands anybody who needs the lunch. Okay, and we have additional schedules here if you need a schedule. Tomorrow you need a lunch box?
No, I don't. I paid it already.
All right. And also remember about the release questions, the 200 release questions from the National Conference of Bar Examiners. We give you instructions on how to get them. Highly recommend that you get these release questions. We subsidize your purchase. We'll leave this down in front. Just a note, some of you have been sending me essays. I think I'm up to date on reading everybody's essays at this point. If you think you sent me an essay that you haven't gotten comments on, let me know because I probably didn't get it. Did you send me this? No? Okay. You're going to send me another one, but okay. Please feel free to keep sending the essays. As many as you send me, I will read. Now, I'm going to be out of town for a few days, and Amara's going to come in tomorrow for the con law, or the First Amendment lecture that Professor Kang is doing. That'll be a quick one because you know Professor Kang, he likes to fly, but it's a really good lecture. So please come and listen to First Amendment by Professor Kang tomorrow. And again, Amara will be here if you have any questions. Next Friday, Leah Forsch, who is one of our graduates, who is an expert in business entities, is going to come in and do business entities. She does that every time for us. She also does an excellent job. She knows everything. And then a week from Friday, so we're at the very beginning of February, I think it's the second or third, whatever that Friday is, I will do the first of the lectures on essay writing, and I'm going to do torts and contracts. And you know that torts and contracts, it's a big deal. They test it a lot. I will also, at that time, give you my predictions. So if you want my predictions, you come to that lecture. Please feel free, again, even though I'm not here physically, I'm checking my email all the time. Ask me questions, send me email, and I think that's about it, unless we have any questions. Judge Shepard, I think you all know Judge Shepard. He is the Chief Judge of the 3rd DCA. We are very fortunate to have Judge Shepard as a faculty member here as well. He teaches Florida Con Law for us. He's going to give you, as you noticed when you came in, you should have seen. They went, whoa. Very
about it.
Thorough lecture on Florida Con Law, but pay attention. He's an expert in the subject area. It is a very difficult subject that they love to test on the bar exam. And so pay attention to what he's saying, because if you do, you're going to have the leg up on a lot of other people who are going to go into the exam not really knowing this area of the law. So I'm going to turn the floor over to Judge Shepard. We will take a break at a certain point, and at that time, Judge Shepard will do the drawing for the hotel room. Okay, it's all yours.
All right, thank you. And thank you for attending this session so that you don't feel too intimidated by the packet. Let me begin with the packet. The plan today is to work through this set of slides that say Florida Constitutional Law Bar Review Lecture. So what you need to have before you and handy are the set of slides and a copy of the Florida Constitution. So that reduces your paper stack by about half. I also handed out, in case you want to look at it, something called Article 11, Amending the Florida Constitution, which I teach in class, but it has never been tested, to my knowledge. On the other hand, there is always a first time. So that is, as it says, for personal study. Next, you have a handout on original writs by a colleague of mine, Stephen Northcutt. You get these things in New Judges School. And when we get to jurisdiction, I'm going to show you how this little packet works. And it is a great little packet where you can get enough in order to, I believe, handle an original writ question if you get it either in an essay or, more likely, I would think, in the Florida procedure section of the bar. The next two pieces are pertinent to homestead, and they are, one of them, it says Florida homestead issues for the non-Florida lawyer. It's really good for lawyers, and it's a nice readable summary of homestead, which we will spend a good chunk of time on. And then there's a 2-page article piece here on what the federal court, the United States Congress has done to reduce the amount of homestead, to reduce the protection you get in bankruptcy court if you file bankruptcy, down from full protection, which you get under in Florida, down to about $125,000. Finally, there's an article here by actually another colleague of mine, Jim Wolfe, up in Tallahassee. This I strongly recommend that you read, and it is not that you're going to do it today during the course of this, but it summarizes local government and tax and finance. Article 7. Article 7, tax and finance, is probably the toughest article of the 12 articles of the Florida Constitution. There's nothing else like it in the state of Florida, and even in other states. Every state is different. This article, which is it's only 10 pages, and it is a great article to later on tonight or over the weekend, just read through it, and it will help pull together two sections of what we are going to talk about today. So, you can set aside for the moment everything except for the bar review piece, the overheads, and your copy of the Constitution. I do take questions as we proceed. So if you raise your hand, I'm happy to try to answer the question. We will cover the articles and sections of the Florida Constitution that are most tested. I have read at least 20 years worth, I think, of bar questions. And so that's the plan. We will not dally at all. And what we will do is we will spend our time on the ones that are highlighted there. Articles 1, 3, 5, 7, and 8. And then one section of Article 10, the homestead section. We will go somewhat in order. So let us begin. We start with a basic proposition, and that is the doctrine of separation of powers. Florida has an express separation of powers provision. No person belonging to one branch shall exercise any powers appertaining to the other branch unless expressly provided therein. The 2 points to remember, with respect to separation of powers are the highlighted points. All right, what did I do? Oh, I took this out, probably. Can somebody help me? The 2 points to remember are the 2 points at the top of the separation of powers chart. Thank you. I'm trying to get this so I can have them together. And they are the two basic principles. Number 1, no branch may encroach upon another. And number 2, no branch may delegate its constitutionally assigned power to another branch. That's what you need to remember and understand. if you want to read a single case on the subject, I would recommend the Childs versus Children A through F case that is in the upper right-hand corner of that chart. It will give you a very good background. Sir?
As we go through this, are you going to identify anything that might be different from the U.S. Constitution? Or does it matter at all if it does?
Well, I will occasionally reference the United States Constitution. I think for separation of powers purposes, you can use what you learned there. I know there is a non-delegation doctrine and I don't know what they call it, encroachment. But most of what we're going to do today, and this is, people just don't fully appreciate this, most of what we're going to do today is not found in the United States Constitution. The Florida Constitution, you just look at the packet there, and it's, well, 175 sections, for example, 12 articles, 175 sections. You cannot count on using what you learned in United States constitutional law to get you by in Florida constitutional law. A Florida constitutional law question will be a Florida constitutional law question. It will not be, for example, your ordinary search and seizure question, because there, Florida and the United States Constitution are linked, so it's unlikely to be that. It's much more likely to be these types of things you will see momentarily. So the two basic provisions that you need to remember, these two. With respect to, let me just give a couple of illustrations, okay, since this is something with which you are somewhat familiar. A couple of illustrations that you will see, and these are drawn out of past exams. You might see an exam question that has the title, An Act Relating to Reform of the Courts. And the types of things where your antennae should go up on separation of powers and other issues that we will talk about, but on separation of powers, for example, it would be if you saw a provision that would say that any claim of medical malpractice shall be tried before an administrative hearing officer, pushing it off into administrative law. Because intuitively we know the courts have a purpose. Another example would be something would say any mortgage foreclosure case shall be tried before an administrative hearing officer who will have full powers to enter a judgment as a court. Your antennae instincts should go up, should take over. Another is for simple divorces. If you see a provision that says any simple divorce shall be handled in an administrative agency to try to get things out of the court for efficiency purposes, that'd be the context perhaps, your antennae should go up. One last one. Again, in the divorce context, because I've seen this in the bar. Any judgment in a family law case shall be automatically appealable to the Florida, any family law case shall be first tried in an administrative tribunal by a hearing officer and then appealable to a district court of appeal. So those are examples, and I would suggest to you that if you know those two, if you take a look at the case and think about a few examples, you'll be fine there. The next piece, the next article that I want to cover with you is Article 3. Article 3, we go from 2 to 3. The legislative article of the Florida Constitution. There are two areas. There are two areas that I want to emphasize. One, I want to emphasize the types of laws that are passed by the Florida legislature. And I want to emphasize Florida's single subject rule. We start with types of laws. There are 2 slides on the subject. The first, there are 4 types of laws in this state that the legislature will use. They are general laws, special laws, general laws of local application, and appropriation acts. Appropriation acts are easily dealt with. They are a subcategory of a general law, and with respect to appropriation acts, the provision of the Constitution is clear. Laws making appropriations for salaries of public officers and other current expenses of the state shall contain provisions on no other subject, meaning that there can be no policy type conditions or requirements in an appropriation act. All policy type laws must be one of the other 3. They might be a general law. A general law, as you would expect, is a law that operates universally throughout the state. It does not have to be universal in application. For example, there is a general law in this state that if you're going to drive a car, you need to get a driver's license. But it does not have application to everybody, every citizen of the state of Florida, because some people do not drive. So it does not have to be of universal application. But it has to operate universally throughout the state of Florida. It has to be applicable everywhere. The other significant point with respect to a general law is that the legislature does not have to give any notice to promulgate a general law. It can go up there and it can pass a general law so long as it's a true general law and applies throughout the state. That is to be distinguished from a special law. A special law is a law designed to operate upon particular persons, places, or things. It could operate, for example, on a single county. There's a case out there of where a special law was passed requiring all dogs in Pinellas County to be vaccinated for some reason. That is a special law. However, with respect to a special law, there are 2 other conditions, and here you need to look with me. Please look at your Constitution with me. Go to Article 3, Sections 10 and 11. We're going to go in reverse order. 11. Article 3, Section 11. Article 3, Section 11 says, it's entitled Prohibited Special Laws, but read carefully. There shall be no special law or general law of local application. That's one of the 3. One of the 4, but one of the 3 that are interconnected, if you will. There shall be no special law or general law of local application pertaining to, and then there is a whole list. Intuitively, if you look at a half a dozen of them, you'll appreciate that you wouldn't want there to be special laws applying to North Florida versus South Florida in these particular areas. These areas include assessment or collection of taxes for state or county purposes. A state sales tax of 5%, whatever the base sales tax is a statewide tax. More evident would be rules of evidence in court. You wouldn't want the rules and evidence in court to be the same in, or different in Duval County than there are in Dade County. Punishment for crimes, the criminal code, same general point. Divorce, there's a good one. You wouldn't want the rules for divorce to be, the laws relating to divorce to be different in one place to another. Disposal of public property, sale of public lands, and so on. So if you look at that list, which applies, I say again, not just to special laws, but general laws of local application. A general law of local application is a general law. It is a special type of general law. I've already said that there is no need, there's no requirement that that notice be given by the legislature for the promulgation of a general law. That applies both to general laws and general laws of local application, which we will define momentarily. However, sir.
If I understand correctly, then, if, going back to your example about a dog being vaccinated in a particular county.
Right.
Before the legislature could pass that law, a notice would have to be published in a newspaper that they're working on this, and people would have an opportunity to respond, I suppose?
They'd have an opportunity to write their representative or have their say.
All right, but if it's inoculating dogs throughout the entire state, that's it. You're not told about it.
That's right. A general law that would require every dog in the state to be inoculated against rabies would not require notice. A general law, a criminal law. Criminal laws are general laws.
Sure.
And so a criminal law that says that all dogs in the state of Florida must be inoculated, or else it's a misdemeanor. You know, it's a misdemeanor not to do it. That would be a general law. But the case that I'm referring to happens to have been one that, for whatever reason, applied only to Pinellas County. Maybe they had a problem back then. To follow up your point, Mr. Minton, I've said general laws do not require any notice, whether it be a general law or a general law of local application. However, with respect to special laws, which apply to a particular person, place, or thing, sometimes, by the way, called local laws, but they're exactly the same thing. A local law might apply to Fort Myers or something like that. In addition to the requirement that the law cannot pertain to any of the listed subjects, there's one additional requirement that Mr. Minton just raised, and that is the requirement of notice. The notice may be provided to those, well, it must be provided to those affected. If it's Palm Beach County, then notice must be provided in Palm Beach County. And there are two ways to do it, two ways to pass a proper special law, notice-wise. One is, as Mr. Minton says, publish it in the newspaper on a certain number of occasions as required. And the second way is to put a condition on it, on the proposal, that it will not be effective until approved by a referendum of the affected people. My example, the people of Palm Beach County. That leaves general laws of local application, the toughest probably of the three. General laws of local application are also known as population acts. They are general laws, but they will only apply to people or to people usually, almost always people, that in areas that meet certain conditions. The conditions are set forth on this slide. If you see a general law of local application, what you think is a key would be a question, not always, by the way. I mean, you can get tricked easily. But a key would be a question that says something like, this law shall apply only where, in instances where somebody has to cities that have a population of 300,000 people on a particular date. That would be a candidate for general law of local application analysis. If, and by the way, it's this case that I just mentioned, if you see something that has a number in it, okay, that will take us to, that will require the following analysis. And the type of law that I'm thinking about is one that applies to a political subdivision of the state. I get that from Article 3, Section 11, in the enactment of general laws on other subjects. That's other than the list. Political subdivisions or other governmental entities. So we're talking about political subdivisions or similar types of entities may be classified. That's a general law of local application. It's the classification. Only on a basis reasonably related to the subject of the law. When you parse it through, the best way, here are the three requirements. You go from bottom to top is the way to do it. First, if you see something, as I said, that says the facts say that that this particular law applies only to cities with a population of 300,000 or more on a particular date, or alternately, this is another real case, older case, that this particular law prohibits nudist colonies in counties that have a population of between 36,500 and about 40,000. That's if it gives you population numbers, antennae should go up. And you look at it, either of those two hypotheticals. First thing says that law cannot pertain to any of the forbidden categories in Article 3, Section 11A. You won't be able to remember all 20, shouldn't have to, but you may remember the idea and some of them, criminal code and venue and things like that. And if it does, that's the end of it. But if it doesn't pertain, then you go to the next one. The population classification must be open-ended. The rationale behind that is this is a general law. So if, in the case of the two hypotheticals that are real cases that I gave you, there's not the ability for other political entities to come in and get the benefit of whatever the law is, then the population is not open-ended. The theory behind it being, if it's not open-ended, it's not a general law. If it passes muster on those two, the Population Act, the Act must be reasonably related to the population classification. That means it has to be, essentially, it has to have a rational basis for its existence. In the case of the 300,000 person one, a law that would pertain to communities that have, to cities that have a 300,000 limit, it would have to be with respect to a tax, that can pass muster. However, in the other hypothetical I gave you, the one about the nudist colonies, that failed right there, because there's no reason whatsoever to prohibit nudist colonies only in areas that have 35,000 to 40,000. It's not an easy concept, but this has been tested on a couple, 3 occasions at the minimum. So there are your laws, and the way, I'm about 5 minutes behind, right?
You're actually pretty
Close, all right. Then the test question, let me see here if I can do this. The test question that you're likely to see, let me use the 300,000 one, okay? City of Miami. I'll try to do it quickly. In City of Miami versus McGrath, the state legislature passed a law that said that if a city in the state of Florida had 300,000 people as of April 1 of 1999, then in its discretion it could hike its sales tax or add an additional half penny to its sales tax to pay for additional parking facilities. A person in the city of Miami, there were only 3 communities, by the way, in the state in 1999 that had 300,000. Miami for sure, maybe Tampa, maybe Jacksonville. So there are 3. A citizen of Miami, city of Miami, or somebody who was parking there, sued to invalidate the law, didn't want to pay the extra half penny. And there was no notice given for the law. Remember, the government has to demonstrate, or it has to be demonstrated, that the law is one of these 3, or it's unconstitutional. Clearly, it's not an Appropriation Act. We don't need to worry about that, right? So we go to the others. There was no notice. So if you're analyzing this, if you're the judge or the test taker, all right, let's find out if this is a valid special law. Is it? Well, does it apply to, is it valid or is it invalid? Is it one of the forbidden categories in Article 3, Section 11, one of those 20? No. That's good. So far, so good on special laws. But look at 10. Shall be passed, there has to be notice, published in a newspaper or a referendum. Neither one of those exists. So the city of Miami cannot justify that law, you being the judge or the test taker, by reference to a special law. 2 left. General law. Is it a general law? General laws do not have to be universal in application, but it must materially affect the people of the state and operate universally more importantly, operate universally throughout the state. Does this one operate universally throughout the state? No, it does not. It only operates in 3 areas. So it's not a general law. The city has one last chance. General law of local application. We go from bottom to top. Cannot pertain to any of the 20 forbidden categories in Article 3. It's not invalid there because it's not among the 20, just as it was when we were talking about special laws. The population classification must be open-ended. Was this one open-ended? No. It applied only to cities that had 300,000 people as of April 1 of 1999. The next city that came along that had 300,000 people could not take advantage of the law getting an additional half penny. That's as far as you really need to go. Because if you got to pass all three, pass muster under all three, but under the reasonable basis test, or however you wish to articulate it, yeah, it's reasonable to try to help out big cities that, in this particular case, go bankrupt. That was kind of the basic.
If that law was written absent the date on it, in other words, the cities that have $300,000 or more,
Yep.
would you consider that open-ended?
Yes,
So the date closes it.
correct. That was the problem with that, and it doesn't pass muster under any of the three, and at the end of the day, it's really an invalid special law because it's looking at some places. Yes,
So
ma'am.
all three must be present in order for it to qualify. It must fit into the definition of one of the laws and not completely.
Yes, yes. You cannot, with respect to the laws passed by the state legislature, there are 4 types. I put them on the board. And each of those 4 types have to meet their respective requirements, or they're unconstitutional, whichever one it is, whichever type of law it is, or it's unconstitutional. It has to meet the requirements of one of the 4. Okay, the next subject. The next subject that is equally important, that is tested a lot, is Article 3, Section 6, the legislative single subject rule. Article 3, Section 6, look at your Constitution. Article 3, Section 6 says, every law shall embrace but one subject and matter properly connected therewith, and the subject shall be briefly expressed in the title. What is the purpose? The purpose is to preclude. This applies, you see it in the area of general laws. Theoretically, it's possible to see it in other areas. But really, think general laws with me, okay? A general law. But, so, every law shall embrace one subject and meet a title requirement. So there are 2 requirements in Article 3, Section 6. On the exam, look for both. Oftentimes, a student or test taker will just, the antenna goes up on the single subject because it's obvious. You see a law that has a civil side to it and a criminal side to it. Aha! That triggers Article 3, Section 6. But embedded in there, in the paragraph, will be something with respect to the title. Talk about the title. Say something about it. Either it's okay or it's not okay. Is the subject briefly expressed in the title or not? Say something, it gets you points because the grader says, aha, the person at least recognized there were two things to talk about. Back to substance. The purpose of the single subject rule is to prevent log rolling. Be sure to prevent legislators from putting an unpopular idea together with a popular idea and thereby getting all of the votes necessary to pass the law. An example that I reference here. An example, the lead case on it actually. There was a law passed in the not so distant past that increased criminal penalties if you've had certain number of prior convictions of certain types. Passing laws that increase penalties is a popular thing for politicians to do because they get votes for doing that. The other side of this same law, this chapter law, included a provision that said that if it provided for a cause of action and damages, okay, a civil cause of action, not a criminal cause of action, a civil cause of action for violation of an injunction for domestic violence. This was not your usual domestic violence sort of criminal law at all. This was a law that provided for damages if the individual for damages if you violated the injunction to stay away from somebody. If you violated it, you could also obviously be put back in jail for it. But this was different. So you had a criminal law and a civil law. Florida Supreme Court looks at this, and it says that this violates Article 3, Section 6. Sort of sounds close, but you have to read the problem carefully to appreciate that there are two different things being talked about. If you see that, your antennae should go up. At the same time, look at the title, because the title is intended, B, to prevent surprise or fraud, or C, to fairly apprise people of the subjects of the legislation being submitted. If the title of this, happened to be simply a law to enhance criminal penalties, the title would also have a problem, in addition to the subject. So look at it. Another and final example on this that I want to give you, and this actually is in your materials. I'm already looking ahead at about the 20th page in, and I'm referring now to an exam question from the past. Here was the question in part. You are an associate at a firm that represents plaintiffs. The legislature recently passed an act titled, "An Act Relating to the Reform of the Courts." The terms of the act are: the Florida Supreme Court shall have jurisdiction to review a decision of a district court of appeal affirming a final judgment exceeding $1 million. All med mal claims, as I said earlier, will be shifted over to an administrative officer. And finally, it is a second-degree misdemeanor to pass a school bus that displays a stop signal. Just think of those three together. We have here, the Florida Supreme Court shall have jurisdiction to review a final judgment exceeding $1 million. That's a civil, that's a jurisdictional matter. The second one I mentioned, med mal, shifts over to the administrative hearing officers. That's jurisdiction. Those two together are fine. Nothing wrong with that. They're all a single subject, and they also actually kind of fit under an act relating to the form of courts. So you'd write something about the act relating to the form of courts, so that looks okay. But then you get down to this other point, second-degree misdemeanor to pass a school bus with a stop signal. That's a criminal law, totally different. So in analyzing, doing the analysis, you would, hopefully, I'm sure, you would say the title of this probably passes muster. Maybe not because of the school bus problem or issue. Does or doesn't matter what you say, you just have to say something. And that it's a violation of the single subject rule, which has been summarized down in the last little line on this slide. In order to pass single subject muster, the sections of the bill must have a natural and logical relationship to each other. If you can remember that much, that's probably sufficient. In addition, talk about the title, of course. All right. I think we are now up to the judicial branch. How am I doing? Good so far. All right. The judicial branch. This is highly tested. If you're following the train of what I'm talking about here, you will see that separation of powers applies across the board. Then you come up to the legislative branch, and we see that there are two major pieces to try to remember. One is types of laws. Another is single subject. If you just step back for a second and think about it, you can see how those two subjects alone could be placed into a hypothetical that relates to and includes a legal proceeding, a court proceeding. And the others that I'm going to talk about as the time goes on fit the same mold. Therefore, what we are now about to talk about is important because it oftentimes is the shell, the structure by which these substantive portions of the Florida Constitution are analyzed. The judicial branch. Here we go. Look at your chart and turn please to Article 5. Article 5, Section 1 through 4. Put those in front of yourselves, please. First, with respect to jurisdiction, I'm going to start at the top. We're going to go from the Florida Supreme Court all the way down to the lowest trial court. But first, we have to divide the jurisdictional world into two parts. There are appeals and there are original proceedings. Appeals is where I want to spend most of our time, but I don't want to totally neglect original proceedings because even though, to my knowledge, they've never been tested in an essay, they have been or could easily be tested in Florida procedure, as could, by the way, appeals. But original proceedings probably more likely in Florida procedure. What's the difference? An appeal is plenary in nature. You get to go to the court. The court has to take it. And appeals come in, there are two types of appeals. We're talking about appeals. There are plenary appeals from final judgments. That means an appeal from a final judgment. You can forget the word plenary. Or there are appeals from specified non-final orders. And there's a list of those, as we will see 2 slides from now. Original proceedings are writs of certiorari mandamus, quo warranto, which you don't need to worry about, habeas corpus, and a couple of others. We're going to see them all. So appellate jurisdiction, which is where we're starting from the top down, Supreme Court down, has 2 areas. As I said, appeals. An appeal, whether it be an appeal from a final order or judgment, end of the case, a judgment for damages, a declaratory judgment, whatever it might be, but appeals from final judgments and selected non-final orders are mandatory for the court, which means that all the losing party has to do is file a notice of appeal. File a notice of appeal. appeals arise from the case below. They exist. They exist to review whatever happened, whatever occurred below. And the purpose of an appeal is twofold. One is to review the order or final judgment for reversible errors that occurred any time prior to the entry of that final judgment. It doesn't mean every error, reversible errors. And the other test that is used in reviewing a final judgment, anything that occurred before that final judgment, or non-final order, anything that occurred pertinent to that order, the other type of test used is abuse of discretion. That is different from original proceedings, the 6 writs that we're going to talk about. There is no, the original proceedings are not, writs are not mandatory. A petition is filed in the next court above the court in which you're in. For example, if you were in the trial court in Dade County, circuit court in Dade County, and had something that fit the elements for a writ, you'd file a petition in the next court up, which happens to be a district court of appeal. Those petitions, with the exception of certiorari, those petitions, the other 5, can pertain to matters only that are collateral to the main proceeding. Certiorari is different. Take a look, if you would. It's now time to open up the Stephen Northcutt piece and go to page 1. Page 1 has on it what I have just covered. I should have told you to open it up before I started covering it. Nevertheless, there it is. Appeals are mandatory, arise from the case below, and review the merits of that case, and have 2 purposes. One, looking for reversible error, or secondly, whether the judge abused his discretion in some particular way, usually evidentiary type calls. Original proceedings are discretionary, originate in the next court above, with the exception of certiorari. They are collateral to the proceedings that are ongoing below. I want to set this half aside. I want to spend time now talking about this half, appeals, and then I'm going to fold back into writs. Please turn to Article 5, Section 1, I've already said. Article 5, Section 1. The important piece about Article 5, Section 1 is first sentence. The judicial branch, first 2 sentences. The judicial branch shall be vested in a Supreme Court, district courts of appeal, circuit courts, and county courts. Then I'm going to emphasize, no other courts may be established by the state, any political subdivision of the state, counties, or any municipality. There are only 4 courts in this state. There can be no additional court unless the Constitution is amended by the people of this state. So that with respect 2, my medical malpractice example, or my divorce example, or my foreclosure example. That exam point. In addition to talking about separation of powers, your intent, I should go up and say that test, that question also is seeking to create another court. It's just called a different name, a hearing officer, hearing court, whatever they want to, whatever you happen to see. So now you have two reasons, two things to write about that particular thing. And you'll find that the divorce one has been in a question, and the one about med mal has been in a question, okay? So that's an additional thing to start folding in. So there can only be 4 courts. The next sentence of importance is in Article 5, Section 2 in your handout there. Article 5, Section 2, the first sentence. The Supreme Court shall adopt rules for practice and procedure in all courts. All courts. The Supreme Court is the supervisory court in the state of Florida. It sets the rules for every court below it. District courts of appeal, circuit courts, county courts. In the circuit courts, there are many branches. There's the family court, there's the probate court, there's the regular civil court, there's juvenile court, all sorts of things. There are sets of rules. The reason I emphasize that is that in the hypothetical that I'm using with you, there is a provision that makes the hypothetical additionally unconstitutional, and that is a line, a piece of the proposed chapter law that says, any rule of procedure promulgated by the Florida Supreme Court shall be presented to the governor for approval in the same manner as passed by the legislature. What are we going to think about? We're going to think about separation of powers, and we're going to think about the Supreme Court is the one to adopt rules. So there are two quick things to write about. And you can write about them briefly, perhaps, but you got to make the point. From there, we look, once we get the structure together, we obviously have a Supreme Court. We have 5 district courts of appeal in this state, populated by a total of 60 judges. And we have 20 circuit courts in this state, 20 circuits, counties together. And each the county courts, the 4th one down, 4th is a court of limited jurisdiction. Every county is a county court. So that's the hierarchy. With respect to jurisdiction, the source of jurisdiction for all of those courts begins with the Florida Constitution. With respect to the Supreme Court, the jurisdiction of the Supreme Court is almost entirely set out, established by Article 5, Section 3B. Take a look at it, please, with me. Article 5, Section 3B. That section, in addition to establishing that section establishes the jurisdiction of the Supreme Court. That section has everything in it that I have summarized here, so don't think that I'm trying to give you a lot of additional stuff to memorize. This is just sort of something to look at so you can remember a few. Yes, sir? We're going to come to that in about 30 seconds, okay? Invalid's the answer. You have to answer every question. Invalid. Invalid, well, there's invalid and valid. I'll use that in 1 second. The Supreme Court is a court that its jurisdiction is laid out right there in Article 5, Section 3B. And for our purposes, that's it. That's it. If you know what's there, which I've summarized in part here, you'll do just fine. Okay? It is a court of limited jurisdiction. The very few cases get there. It is a supervisory court over all of the other courts. It is also a law-declaring court. Those are the three characteristics. The latter invokes the notion of clearing up conflicts between the 5 district courts of appeal because they are autonomous and almost always the court of last resort for litigants in this state. You only get one appeal for the most part in this state. Rarely do you get more. There are a few areas where you can easily get to you have a better chance of getting to the Supreme Court, although I don't recommend it. There are 4 and only 4 grounds of mandatory jurisdiction, mandatory appellate jurisdiction, the left side of the earlier charts in the Florida Supreme Court. It's court of limited jurisdiction. There's mandatory jurisdiction in death penalty cases. Those cases go directly from the circuit court. They skip over the district courts of appeal, thank God, and they go directly to Florida Supreme Court by appeal. The defendant has an automatic right to appeal and does. The next one that you are more likely to see are mandatory jurisdiction in cases invalidating a law by the district court of appeal, by a district court of appeal. Cases in which a district court of appeal, the next level down, any one of them, finds a law unconstitutional. I emphasize the un for you. And the reason for that, if you think about it for just a second, is fairly reasonably obvious. It's a serious thing for one branch of the government to tell the other branch of the government that they're acting unconstitutionally. The legislature doesn't like that when it happens. And so the safety valve is the Florida Supreme Court, and it's an automatic appeal if anybody takes it. The next 2, bond validations proceedings, a little esoteric. However, we will speak about what makes a bond, which is a mortgage in the private world, valid or non-valid. Those go automatically from the Supreme Court up to the Florida Supreme Court, the trial court, the Supreme Court, because of financing reasons. If you're going to borrow money, you want to get the job done quickly. Lastly, I wouldn't worry about, but there is there's an automatic appeal from orders of the Public Service Commission. There's only one statewide agency that has anything to do with rates and services. The main one probably to remember, if you only remember one, is cases invalidating finding unconstitutional a provision by a district court. Still referring to not Article 5, Section 3B. The court has discretionary jurisdiction. It means they don't have to take the case. If it's Friday afternoon, they want to go play golf, no problem. As a gentleman here raised a moment ago, there is no automatic appeal of a District Court of Appeal decision finding a law valid. Nevertheless, the disappointed litigant in the District Court of Appeal that was trying to have it declared invalid still has a potential route to the Florida Supreme Court. He or she or it files a petition for review in the Florida Supreme Court saying that the District Court of Appeal erred by treating that opinion and declaring the provision valid, that they should have done just the opposite. The others, these are just kind of the main ones from Article 5, Section 3B. What is known as conflict jurisdiction. There are two types of conflict jurisdiction. Probably if you just know what conflict jurisdiction is, you may get by, but it's a good idea to know, if you can, that there are two types. Depends how much I took the exam long before, half a century ago, and I still remember. You can't remember. It's you put as much in your head as you can. And conflict jurisdiction. There's certified direct conflict and express and direct conflict. Conflict jurisdiction exists when one District Court of Appeal comes out with a decision that is in conflict with another District Court of Appeal. That's how you get it. And that could be, say, in a sentencing arena frequently. That one court of appeal might say that thus and so type of crime is aggravated battery, and the other will say the conduct is not aggravated battery. Something like that. Okay, something just that simple. You can get it in every conflict, every context. When that has occurred, when there is conflict, the District Court of Appeal that has the later case can, if it so desires, recognize in the opinion that we recognize and certify that our case conflicts with our decision with respect to aggravated battery, conflicts with the decision of the 5th District Court of Appeal on aggravated battery. The Florida Supreme Court and the disappointed defendant could file a petition for review based upon that. The disappointed defendant in exactly the same case can seek review even if the District Court of Appeal does not certify conflict. And in that case, the defendant would file a petition for review and in a jurisdictional brief make the argument, present the case to demonstrate why one District Court of Appeal decision conflicts with another. In either case, the Florida Supreme Court doesn't have to take the case any more than the United States District Court has to take a case when there's an opinion of the Third Circuit that conflicts with an opinion of the Seventh Circuit, say. It's discretionary. A couple of others, and then we'll move on. There is an ability provided by the Florida Constitution for the Florida Supreme Court to treat questions of great public importance. It is defined in that's referenced in Article 5, Section 3B3. In those cases, the District Court of Appeal must decide the question and certify that it is a matter of great public importance. The most recent one that comes to mind is that there's a question about whether or not possession of cocaine in order to be convicted of cocaine, whether you had to have mens rea. In other words, know that it was cocaine. That was a big deal in this state because a bunch of people in prison were, would affect a bunch of folks. And so it was certified by the Second District Court of Appeal to the Florida Supreme Court as a question of great public importance. Another district with the same issue certified the same question in what is known as pass-through jurisdiction. And the reason I mention that is that was raised, a little esoteric, I thought, in the question, in a bar exam. And the nature of the question is one saying, well, here are the facts of the case. Tell us whether find all the things wrong with it. And what's the fastest way to get this to the Florida Supreme Court? And the fastest way was pass-through jurisdiction. What is pass-through jurisdiction? It is a situation in which the District Court of Appeal, the issue is important enough that the District Court of Appeal doesn't decide the case, unlike great question of great public importance, does not decide the case, but just certifies to the Florida Supreme Court that this is an important case that needs an immediate answer. You can read the exact language in the Constitution, Article 5, Section 3B. And even then, the Florida Supreme Court doesn't have to take the case. I've had one of those where I thought it was important, they didn't. Well, such is life. The archetypical example of that is, for those of you that watched the 2000 election fracas, all of those cases, most of the trials occurred up in the circuit court in Palm Beach, in Tallahassee. And not a single one of them stopped at the First District Court of Appeal. They were passed through because we all wanted to know who was going to be president. Discretionary jurisdiction. Advisory opinions, the only one that I would be sure that I knew something about probably is Article 4, Section 1C, that the governor can seek an advisory opinion relating to matters directly affecting his powers. The rest of them I wouldn't worry about. Original jurisdiction I've referred to. I'm going to handle original jurisdiction at the tail end because because three of the four courts have original writ jurisdiction to supervise, because that's what original jurisdiction does for the most part. It is used, it is. The original jurisdiction exists so that the court above can supervise the next one below. The Supreme Court, state Supreme Court, is the main supervising body. However, the district courts of appeal have original writ power, supervision power over the circuit courts below them that are the circuit courts in their district, and the circuit courts have jurisdiction over the county, supervisory jurisdiction over the county courts in their jurisdiction. There's one thing that I want to emphasize, and if the rafters would hold me, I'd jump up there and grab it. Maybe they certainly wouldn't. The Florida Supreme Court does not have certiorari jurisdiction. Period. End of discussion. If you see in a question, or if in a Florida procedure question, I think it would be a good spot to find it, that you're given a fact pattern and you're asked, what are the five ways to get to the Florida Supreme Court? One of them is certiorari jurisdiction. The answer is no. So that takes care of that side. How are we doing? Time to move on. Move on to what? That's not good. All right, we'll move on. The main, then we go to district courts of appeal. District courts of appeal, the jurisdiction is prescribed by Article 5, Section 4. As you head down the list, there's less in the Constitution, more by statute. What do the district courts of appeal do? They are the workhorse of the appellate courts. They review all final orders. I mentioned it, and all non-final orders that they are permitted by rule to review. Remember, I said in the first slide there's an ability to appeal from final orders and non-final orders. Well, here's your list of the main non-final orders, meaning orders from which the rule allows, the rule that is authorized to be adopted by the Florida Supreme Court. To review non-final appeals, and they are the main ones that listed: personal jurisdiction, class actions, immediate right to immediate monetary relief, or child custody and family matters. Just looking at those four, similar to the Article 3, Section 11 that I spoke about a little earlier, where you had this list of things that you wouldn't want to have different types of laws statewide. Analogously, and only analogously here, you can't wait to the end of the case if child custody is involved. Think divorce cases, okay? They go on for a couple of years or more sometimes. If there's a child custody order entered by the court during the course of the case, and somebody wishes to contest it, that's something that you need to have the ability to immediately go up to the Court of Appeal, District Court of Appeal. That's one. Another is usually one side or the other has all the money. In order to equalize the playing field in the divorce, you're entitled to an order giving the other side some money. If that doesn't happen, or if there's a problem, that goes up on an intermediate basis. Arbitration, there's a good one, actually. Arbitration, if you wait to the end, if the trial judge says, no, you're not going to arbitrate, and you wait to the end, and then you finally get the District Court of Appeal to say you can arbitrate, you've essentially lost all of the benefit of arbitration. Personal jurisdiction, same sort of thing. If you shouldn't be there in the first place, or venue shouldn't be in Dade County but should be in Orange County, those things are non-final. And then you have the writs, which I said I'm going to come to. Next, circuit courts and county courts. Again, this should not be as imposing as it might seem, because we can get on top and look down to this on this subject. The jurisdictional source for circuit courts and county courts is in Article 5, Sections 5 and 6. As you continue to go down, as I said, there's less in the Constitution and more by statute, because the Constitution says that's the way it's going to be done. The jurisdiction of the circuit courts I've summarized right here. Circuit courts are the main courts. They're the courts of jurisdiction, general jurisdiction in the state. I think I've already said that they cover the whole gamut of civil cases. With respect to criminal cases, circuit courts handle all of the felonies and domestic violence. They handle bond validation proceedings, which I talked about earlier, that are economically, financially important to move, and they have equitable relief. I'll come back to this perhaps for a moment, and this is all certiorari. So these two I'm going to skip over for a moment and talk about the county court. The county court has, the circuit court has jurisdiction in anything that is not subject to the jurisdiction of the county court by statute. The county court statutes basically give county courts jurisdiction in cases under $15,000, simple dissolutions of marriage, landlord-tenant within that $15,000 range, and misdemeanors. Note that circuit court has felonies, district courts have misdemeanors. The only exception to that is if a defendant has been charged with both a felony and a misdemeanor, because this is something I think one could see, then the law permits the misdemeanor charge to be filed along with the felony charge in one proceeding in the circuit court. Because otherwise, and it has occurred, the smart defense lawyer is going to go in and get a judgment of conviction, try the case, get a judgment of conviction of, say, DUI, and that would operate as res judicata to the, let's say, manslaughter charge, something along that line. So there are the courts. Now, I said we'd spend a few minutes on certiorari. And here's how I'm going to, the statutes, by the way, are all attached there. So you can check what I said. I should say that the appellate, the defendant, of course, has a right to appeal any judgment and conviction, and a right to a lawyer. The state is not so lucky. The state is not a person for jurisdictional purposes, and the state of Florida can only appeal to a district court of appeal those types of orders that are listed right there on that sheet in which you have before you. Suppression cases, a sentence on the ground that it was illegal, didn't meet the minimum mandatory or something along that line, and an order granting a new trial or dismissing an information. The state can appeal, can appeal that. Certiorari. Certiorari, as I said, please go back to the Northcutt piece. Let me show you how this operates. It's kind of cool. Okay. I've already referred you to page 1, the difference between appeals and original writs. So you can review that again if you like, as up against the slides. Then there are excuse me, we know that the district courts of appeal and circuit courts, but not county courts, because there's nothing below them that needs to be supervised, have 1, 2, 3, 4, 5, 6, 1, 2, 3, 4, 5, 6, 7. Did I have it right? No, 6, because I counted habeas and corpus as 2. 6, I knew it was 6. Writs. Well, here's how they work, okay? Let's skip over certiorari for a moment and just go to, let me see where I did this. Aha, here it is. Where did I do this? I marked this off. I know I marked it off easily. All right, we can do this anyway. Yeah, I had one that was easily marked up. Maybe it's here. That's all right, we can do this easily enough. Look at page 9. Page 9, the 5 extraordinary writs, everything but certiorari. That gives you, right there, mark it up if you like, that gives you a thumbnail sketch of what each writ is. What prohibition is, what mandamus is, what habeas corpus is, quo warranto, all writs. Strike out quo warranto, forget about it. And you see that, for example, prohibition commands the respondents to refrain from threatened action that is outside its jurisdiction or in excess of its judicial powers. All of these 5 are, as I said, collateral to whatever the main proceeding is. To take prohibition, for example, you flip then back to page 13 and you'll see prohibition. And you'll see the same definition that you see in page 9 as the lead-in. You'll see the elements of prohibition that you might want to read through and try to remember just to have a good sense of how it works. And then you will see examples of proper uses on the next page, page 14. The main examples of proper use for prohibition are in speedy trial cases or disqualifications of a judge. Note that both of them are collateral to the main proceeding. Note that in this and each of the other 5, these writs, these petitions, are all injunctive in nature. They may not be used. They cannot be used. I'm leaving out certiorari here. They cannot be used for review of an order that has already been entered. Speedy trial, good example. Coming along, criminal cases, a felony case must be tried within 175 days unless waived by the defendant. After 175 days is a little recapture period, but after 175 days, if the state hasn't started the trial, begun to pick a jury, then that defendant gets released. Doesn't matter what he did. He's out of there. So that has nothing to do with who he killed or who he robbed or anything like that. He's released. That's the way our rules work. Disqualification of judge, the same thing. Has nothing to do with whatever this case is about. It's just whether the judge has exhibited bias or not. That comes up under an injunction to toss the judge off the case, and comes up in that fashion. You can continue on here, and I recommend it, that mandamus begins at page 16, exactly the same setup. The definition, bless you, from before, the elements you can use, and the main reason for the use of mandamus is to command, to enjoin a trial court to do something that it has forgotten to do. So in criminal cases in particular, there's so much going on. Sometimes the defendant, the prisoner's motion doesn't get heard. He files a petition for writ of mandamus. In the District Court of Appeal, District Court of Appeal orders or reminds the trial judge to do it. Habeas, habeas is habeas. I think you probably know that about it from federal constitutional law. So it's used for contempt. If somebody says child custody case, somebody's in jail because you didn't pay his child support and thinks that he's improperly there, habeas is the way to get out. Make the government show. I said forget about quo warranto. The last one, page 25, all writs. All writs is not all writs. It doesn't cover anything. You can't use that just in case the others don't apply. All writs. At the top, look at the definition. All it does is protect the court's jurisdiction over whatever the subject matter is. Easy example, family case. The guy's getting ready to take his boat to Bimini so that the trial court can't divide it up. And the judge exercises his all writs power and goes out and takes the battery out of the boat or whatever you do. Certiorari. Certiorari has two purposes. I've tried to summarize. It's hard to summarize certiorari. No, where are we? Certiorari is summarized here. Where is it? There it is, a summary. The first use, the familiar use for certiorari is actually down at the bottom of this chart. There is, we've talked about non-final orders that are reviewable by appeal. There's some that are not, that need to be reviewed occasionally, and that is done by certiorari. It's a discretionary writ. The likely example is that if Mr. Minton has gone into court and I'm opposite him and he gets an order requiring that I turn over my litigation file to him, that order, of course, is enforceable by contempt. I don't particularly want to go to jail. I've seen them. And so I better take that one up right now, and I have 30 days to do it, by the way. And so that's a cat out of the bag situation. Work product is another example of that, those sorts of things that can't wait to the end of the case. The other two areas I would just mention, I think. One is first tier certiorari, and those are applied to cases in which they apply to quasi-judicial cases. Means something that's judicial in nature as opposed to legislative in nature. Quasi-judicial cases that are not otherwise appealable to a district court of appeal or the Florida Supreme Court. Remember, the Florida Supreme Court has jurisdiction in the Public Service Commission cases. And they apply typically to land use. In land use, a land use circumstance would be a good example of it. The commission denies somebody a site review order, something along that line, refuses to approve a developer's site plan. There's no right of appeal there because it's an administrative matter. It goes by certiorari to the circuit court, and then from there by certiorari again to the District Court of Appeal if somebody wants to continue it on. But there is no certiorari to the Florida Supreme Court. Remember that. Okay, that's it for that litigant unless he can show something like conflict jurisdiction. No certiorari to the Florida Supreme Court. The next area is with respect to appeals from the county, non-final appeals from the county court or, strike that. Review by a district court of appeal of orders of the Circuit Court Appellate Division. Remember, Circuit Court Appellate Division has jurisdiction over the county courts for review purposes. All right, I think that if I do not stop, Dean Singer is going to fire me or something. I don't know what she's going to do to me, but I suspect it's something. I'm sure she can. Do you want to take a break now, or do you want to go?
Kind of up to them. We do want to try to get them out as close to 6 o'clock as possible. So, and I know the second half is pretty heavy duty.
All right, we're only going to. Here's the deal. I'd just as soon do local government now, if y'all can sit. I'll do it in 10 minutes, I promise. And if I don't, Mr. Minton, who knows me well, will do something to me. And then we're going to take a 10-minute break, because if I don't end at 5 o'clock or 6 o'clock, terrible things happen. Local government. Local government sets the groundwork for the tough stuff that Dean Singer just mentioned. Two things you need to know. Here are we have the state obviously at the top. Here are all the types of local government that exist in this state. 4 right there. There are counties, there are school districts, there are municipalities, and there are special districts that can be created by any of the above. Municipalities, counties, or the state. Not usually school districts. They could, but Why the line? The line is there because above the line, these three, for our purposes, meaning the county courts, counties, and school districts, have the same status and same degree of sovereignty as does the state of Florida. Why is that? Because they are political subdivisions of the state set forth in the Constitution of the state of Florida. With respect to counties, see Article 8, Section 1. It says the state shall be divided up into counties. With respect to school districts, look at Article 9 of the Florida Constitution. It will say that every county shall be a school district. Contrast that to municipalities. Municipalities, there's no requirement to have a municipality. There's no requirement to have the city of Miami or city of Jacksonville. They can be created, abolished, modified by the state legislature. And I have to take out Dade County in that. Yeah, okay, city of Miami is fine. Special districts like the South Florida Water Management District, if you're aware of that district, a special district of several counties, as it turns out, the purpose of which obviously is to manage the water in the region. There's a reason why I put that slide up, because it becomes important with respect to taxation. We will learn that counties can tax land, and that counties can under certain conditions that we will learn, can assess ad valorem taxes against certain types of property owned and used by a municipality. The same rule applies to special districts. That's why we have that. The other thing you need to know about local government for our purposes is also found in Article 8. Article 8, Section 1. In fact, all of these are. Political subdivisions, I just showed you what that is. There it is on the screen. You need to know the difference between a charter county and a non-charter county. You need to read F and G carefully. There was an exam question that was solely based on charter versus non-charter. And the question was, well, under this condition, and assume it's a charter county, what's the outcome? Under this condition, assume it's a non-charter county, what's the outcome? If you don't know the difference between the two, you have a little bit of difficulty. What are the differences? Here they are. With respect to a non-charter county has no charter. Charter counties do. They have a document, like a constitution. And so the state has more control over non-charter counties, and a non-charter county may not adopt any ordinance that is inconsistent with general or special law. In other words, they must obey both when they're passing a county ordinance. And in addition to that, a county ordinance that is in conflict with a municipal ordinance is not effective within the municipality. Those are the two things. Underline them, yellow them up, whatever you want to do. Charter counties obviously have more power. Charter counties, the state cannot pass a special law relating to charter counties unless the voters of that county approve, because they have their own constitution. And the charter county gets to determine what will control, which will control in the event of a conflict between ordinances, between a county ordinance and a municipal ordinance. Those are the four items to remember there. And with respect to municipalities, my point that I made earlier to get them below the line is found there in Article 8, Section 2. Hopefully I did that in 10 minutes. Can we take 10 minutes, or do we need to go longer for the break? 10 minutes. Okay, it is 22 minutes of. Everybody will be back here at 12 minutes of the hour. Don't be late. All right. We now approach the two most difficult articles of the Florida Constitution, and two which are unlike. I think you've already seen that we already see a whole bunch that's not like the United States Constitution. Well, these are not even close, okay? Tax and finance, not close at all. Here's what we're going to do. We want to know how the state and local governments in this state, the 5 that I listed there earlier, how they raise revenue. They do it in 3 ways. They do it by taxing people. They do it by what I call non-tax revenue raising methods, and they borrow. Borrowing is bonds. It's mortgages in the government world. In order to appreciate taxation, that is, which entities have the have the taxing power, you need to understand how Article 7, Section 1 and 9 fit together. I need to get my notes out. I should have done this already. All right. Follow me. Article 7, Section 1 begins, no tax shall be levied except in pursuance of law. That's important. It sounds like nothing, but it's important. I mean, that's important. Then it has an exception, no state ad valorem taxes shall be levied upon real estate or tangible personal property. All other forms of taxation shall be preempted to the state except as provided by general law. We've talked about general law. So, no tax shall be levied in pursuance of law. That begs the question, what is law? Law can be either constitutional law, constitutional provisions, because the Constitution is law, or it could be statutory law. So we look first into the Florida Constitution to see whether there's any law that authorizes taxation, and we find one. Article 7, Section 9. Counties, school districts, and municipalities shall, and special districts may be authorized by law to levy ad valorem taxes and may be authorized by general law to levy other taxes for their respective purposes, except ad valorem taxes on intangible personal property, which, if you do the logic, fall back over here. That's a big mouthful. What it says is that counties, school districts, municipalities shall, that's mandatory, be able to have the power to levy ad valorem taxes. What is an ad valorem tax? An ad valorem tax is a tax on the value of real estate or tangible personal property, or intangible personal property over on this side, the state taxing power. So those 3 entities have the power to levy ad valorem taxes on the value of the property. A house in Dade County is taxed, okay, by ad valorem taxes, the value of the property. Furniture in an office building, if you have a law firm and you have desks and things like that in it, Once a year, you're going to have to declare the value of those desks and computers and so on, and pay the county an ad valorem tax at a particular rate called a millage rates. So that's one way. And special districts, of course, as I said, special districts, if authorized by general law, may levy an ad valorem tax. Special districts may be authorized by general law to levy an ad valorem tax, and all of them may be authorized by general law to levy other taxes. In other words, say it slightly differently, the power to tax lies in the state of Florida, in the state government. It is there by the Constitution. Local governments only have the power to tax that is provided to them either by the Constitution or by the state legislature by law. If the state legislature desires to provide a taxing power, let's call it a sales tax, provide that power to, or some of that power even, to counties, it must do it by general law. It may not authorize, the state of Florida cannot authorize any unit of local government to levy a tax by special law. It cannot authorize Pinellas County to levy an extra half penny. If it does so, it has to authorize everybody, or it has to have or do it by general law of local application. It has to be a general law. The reason for that is because there's a constitutional desire to have certain taxation over in the state side and other taxation over in the local government side, so that the legislators are not just giving out favors of taxing power. I'll explain as I go. With that statement, that is that no tax shall be levied except in pursuance of law. Counties, school districts, and municipalities shall, and special districts may, be authorized by law to levy ad valorem taxes, and may, by general law, be authorized to levy other taxes except ad valorem taxes on intangible personal property. That's the local government side. The rest is over here. So if you pull this together, and you might want to write this paragraph down. It took me a day to figure it out one time. Thus, pausing to draw together just these two provisions of the Florida Constitution, we know, that except for the express constitutional authority given by the Florida Constitution to counties, school districts, and municipalities to levy ad valorem taxes on real property and tangible personal property, parenthesis, remember, intangible personal property is accepted, close parenthesis. These local political subdivisions of the state and all other political subdivisions of the state, including by way of example special districts and water management district, must have general law legislative authorization to tax. That's it.
Can you sum that up?
That's as good as I've ever been able to do. I've been trying for a decade.
So what you're saying is
besides ad valorem tax, which is only allowed for the county, school districts, municipalities,
Yes.
not the state,
Correct.
any other tax that the county, city, or municipality wants to do, it has to be allowed by general application. By
Correct. General law. General law.
General law.
Any other taxation. The state is the sovereign. The sovereign of all sovereigns. And so there must be a law of some type. There's constitutional law, it's right there. And and in addition, by general law. Okay, general law, not special law. All right. So we have that. Yeah. I do. Let's see, I do. Jumping slightly ahead. When it all divides out, what it means is the primary, I'm going to come to your point. The primary method of tax revenue raising for the state are sales taxes, gasoline taxes, cigarette taxes, excise taxes on liquor and so on, and ad valorem taxes on intangible personal property and corporate income taxes. The state can and has, by general law, authorized counties to assess, if it so desires, a sales tax, a half-penny sales tax. Okay? It has to do it by general law based upon certain qualifications, or a general law of local application if it qualifies. We've already talked about that. And for example, I think in Dade County, I think the sales tax rate's about 6.5% or 7%, somewhere in that general vicinity. And if you go up to Brevard County or one of those other counties to the north, it's at the state level, which is, was it 5 or 6% now, something like that. So there's one example. Gasoline taxes get shared all around, federal, state, and local. Cigarette taxes, probably, and excise taxes, liquor and stuff like that, I just don't, and jewelry, I just don't know. So there are examples. On the other side, since we're on this chart, the major source of tax revenue, I'm talking solely tax revenue now, for local governments is the ad valorem taxes that are assessed on real property and tangible personal property, hard stuff. You're starting to see the divide, I hope. Okay. That takes time to sink in, but it will. All right, so what are ad valorem taxes? I've told you. Taxes on the value of something. The value of the house, $300,000. The value of the desks in a law firm, $50,000, whatever it is. Bless you. The next point, and it's assessed in mills. A mill is one mill is 1/10 of 1 cent. Okay, it mounts up fast. 1/10 of 1 cent. To just make it a little bit, I don't want to dally here, but 1/10 of 1 cent mounts up to a lot of money. $10 per $1,000 of assessed value. So if you have a $500,000 house, I guess you'd divide 1,000 into 500,000, get 500, Multiply that by $10, you're paying $5,000 in ad valorem taxes. Okay? That's the way it works. With respect to ad valorem taxes, I've said real property and personal property is the hard stuff. What is an intangible? What is intangible personal property? Intangible personal property includes stocks and bonds and promissory notes. The largest source of intangible personal property, intangible tax collected by the state of Florida. And again, only the state can collect an intangible personal tax. Is on our promissory notes. When do you sign a promissory note? Anybody who borrows money to buy a house or car or anything like that, you sign a promissory note, and the value of that promissory note is taxed. How is it taxed? Article 7, Section 2. I hope you keep out your Constitution, because a lot of this is right smack there in the text, along with the slides. If you have them next to each other, this all works. Article 7, Section 2. How is it taxed? All ad valorem taxes shall be at a uniform rate within each taxing unit, except taxes on intangible personal property may be at different rates, but shall never exceed 2 mils on the dollar of assessed value. So, all ad valorem taxes on real estate and personal property, the tangible stuff, must be at a uniform rate within each taxing unit. What are the taxing units? The taxing units, if you remember my chart, are counties, municipalities, school districts, and special districts if authorized to levy such a tax. And if the county chooses to levy an ad valorem tax, which all of them do, of course, and municipalities do, then every piece of eligible property in that municipality or county has to be at exactly the same number of mills, 3 mills, 3 1/4 mills, whatever it is. Eligible property would exclude things that would not be included would be like churches and schools and things, you know, the usual sort of charitable operations and so on. With respect to intangible personal property, there's a limit of 2 mils, and that can be in steps. In other words, they could do half a mil on the first 100,000 and mil on the next 100,000 and so on, so long as they don't, the state doesn't go over 2 mils. While we're on the subject of caps, I will jump ahead a little bit and looking back at Article 7, Section 9. Note the bold here. Ad valorem taxes shall not be levied in excess of the following millages upon the assessed value of real estate and personal property. The main ones, counties and municipalities and school districts, are limited to 10 mils. That's all they can tax. That's it. So the local governments are squeezed. All right, let's see what's next. I need to get myself back in. Okay. There are let's summarize here. state and local government taxing power. Article 7, Section 1 is the state. No tax may be levied except in pursuance of law. We've covered that. There are many limitations in Article 7. I've summarized some of them here. There's no state income tax. There's no state inheritance tax in this state. The state's limited on intangible personal property. Corporate income tax is limited, and so on. So the major sources of non-federal tax revenue for the state in their big $80 billion budget, the state budget comes mostly from that. On the other side, for the local governments, counties, school districts, municipalities, and special districts, if authorized by general law, it is largely, as I said, ad valorem tax, and there are lots of exemptions and classifications. For example, motor vehicles are exempt. Homesteads are exempt from taxation up to a limit, $25,000 or perhaps $50,000. That's called common homestead. It is not the homestead that we're going to spend a good chunk of time on momentarily. It's in other words, if you have a $300,000 house, the values drop by $50,000. If you only have a $75,000 house in North Florida, it's dropped only by $25,000. And then there are some various classifications. One that has been tested recently is called the Save Our Homes Amendment. What that does is it's a constitutional amendment passed that restricts local governments from increasing the value of real estate being taxed by to not more than 3% per year. And that was done back in the days when properties going sky high and people were losing their home because they couldn't pay their taxes and insurance and all those sorts of things. So that's one to remember. And there's some others that if you just look through Article 7, Section 4, you'll see agricultural lands are taxed by classification and so on. And the reasons for that are because those type lands typically don't have the value that, say, city land would have. That's the easiest way, a way to do it. So local government is squeezed. They don't have the plenary power that the state does. What do? They look for other ways, things that are not taxes. Things that are not taxes. And there are 3 additional non-tax ways that they raise revenue. One is through impact fees, special assessments, user fees. User fees are exactly what you'd expect. When you file a complaint in the circuit court, you pay $400 or something like that to them. It goes into the general fund. You have a choice. You either do it or you don't. You can, if you want to use the courts, you pay $400. If you don't pay $400. If you want to be a corporation, you send $400 up to Tallahassee with your papers, and it's your choice. So it's a user fee. It's not required. That is not true of impact fees and special assessments. The test impact fees are used anytime a house is built or a developer builds a bunch of houses. And the purpose of an impact fee is not a tax. The purpose of an impact fee is to compensate for costs to the community of the additional construction. There are school impact fees, there are sewer impact fees, there are road impact fees, there are all sorts of other similar impact fees. The test to determine whether an impact fee is a true impact fee is set forth on the left-hand side of the chart. I will not read it. An impact fee is a one-time charge. The other type of fee that is not a tax is a special assessment. A special assessment is a recurring charge. A special assessment can be assessed by a county or a municipality or a special district. And its purpose is to pay for services that are special, unique, if you will, to that district. A good example would be Coral Gables, all right? Coral Gables, there's this road called Miracle Mile down there. And it has a whole bunch of shops and has some buildings and houses on either side. There could be a special district formed by the city of Coral Gables. And the purpose of that hypothetically would be to put in street lights and, things that trees and whatever else makes it pretty, and whatever else you can think of, better parking meters, better lighting, whatever. And they'd form a special district for Miracle Mile and let's say 3 streets on either side. And they would say, okay, you all are getting a special something better that hopefully improves everything. And that charge, so long as it meets the 2 requirements set forth in the middle of the chart, will be a valid special assessment. That special assessment, in order to be valid, the government will have to prove, the city of Coral Gables would have to prove the services at issue provide a special benefit to the property. My hypothetical would probably pass that. The proposed assessments for services, and the second thing, that the proposed assessment must be properly apportioned among the businesses. So, for example, if there's going to be more lighting on Miracle Mile, they should be paying a little more than 3 blocks over where they might not get any lighting at all, but might just get a few, things that look nice, something like that.
So would the toll on the Key Biscayne Bridge be a special assessment?
No, the toll on the Key Biscayne Bridge is a user fee.
That would be a user fee.
Mm-hmm. That would be a user fee. Why does this matter? In addition to the fact that it could be tested, impact fee, I've given you an example. Special assessments, giving you an example. The way these things get challenged the way is that the person who doesn't want to pay it, let's go back to the developer, okay, who's building 100 houses in Broward County and has been told that he or she is going to pay an impact fee of $10,000 per house for the impact that they're having on the sewer system. They need a new sewer system, $10,000, not an unusual number, by the way. The challenger will be the developer, who's going to have to pay that one-time charge. When the lawsuit is filed by that developer, or in the case of a property owner on Miracle Mile, okay, but using the impact fee side, once the charge will be that the exaction, if you will, the exaction is an unconstitutional tax. Remember, all taxes have to be authorized, right, by law. What we're speaking about here have not been authorized by law. So the government has to come in once the assertion is made in a complaint in court saying that the charge for the road fee or the sewer fee or the charge for the extra lights doesn't pass muster. Then the burden shifts back to the government, the city of Coral Gables or Broward County, to demonstrate in the impact fee context, that there is a reasonable connection or rational nexus between the need for additional capital facilities, the sewer system, and the growth of the population generated by the subdivision, the 100-room houses. And the government must also prove, this is an and, a reasonable connection or rational nexus between the expenditures of the funds collected and the benefits accruing to the subdivision, prong 1 and prong 2. That latter point is done by taking whatever the assessment is, whatever the impact fee raised is, the $10,000 per house, and put it in a special bank account, and that money can only be used to benefit that subdivision, i.e. put the sewer system in. Yes, ma'am?
So it's not the developer that charges that impact fee, it usually comes from the government to the developer who is building that particular subdivision?
Yes. In order for the developer to get a permit to build, he will be required to pay impact fees, always. And if he doesn't, he's not going to get a permit. And it's been justified under the police powers to protect the health, safety, and welfare of whatever that community is. So in any given house, if you go up to Broward County and walk into a Lennar development, let's say, and you pick up a $250,000 house and really went and checked it out and worked at it, you'd find $25,000 to $50,000 is because it gets passed through, obviously, is impact fees. And the only way local governments, which are starved for cash, they don't have the plenary power, they can only justify it if challenged, if there's a challenge, doesn't have to be a challenge, is by demonstrating that it is an impact fee. If they can't demonstrate it, it's an unconstitutional tax. Same thing for the special assessments. They must demonstrate that it meets the two prongs. If not, it's an unconstitutional tax. Same thing for a user fee if it was to be so charged. So local governments raise additional money in those three methods. Local governments, some local governments, counties, raise additional money through an additional method of taxation. Look, please, at the chart that I have just placed on the board. I told you. Let's go back to our summary so we know where we're starting, okay? There are three ways in which the government raises, state and local governments raise money. One is through taxation of individuals, corporation partnerships, and other private entities. Another, the next one I'm about to talk about, is local governments. One local government taxing the property, levying an ad valorem tax on another property. This has been tested several times because it doesn't seem to make sense that one government would tax another government's property. It's perfectly lawful and happens frequently. That's what I'm going to talk about now. This one I don't think will get tested on, so I'm going to, and we've already talked about this. Okay, so we're down to, we talked about the taxing powers. We're going to add one on it, and we've already talked about how local governments supplement their revenue. Now, I showed you back in local government the divide. Remember, I had the state up at the top, of course, and I had counties and school districts, and then under counties and school districts, then under that I had municipalities and special districts. And I said they're different, they occupy different status. The upper ones were sovereign, and so they cannot be taxed. You can't tax the state of Florida or counties or school districts. But counties, the sovereign, can can tax municipalities and special districts. That's because municipalities and special districts are not sovereign. They're sort of like corporations, if you will. So how does it work? To what extent can a county tax a municipality or a special district? Here's the law. Article 7, Section 3. Open it up. All property owned by a municipality and used exclusively by it for municipal or public purposes shall be exempt from taxation. So a county may levy an ad valorem tax against any property that is not owned, that is owned by a municipality that is not, exclusively being used for a municipal or public purpose. What's an example? A marina down in the Keys. If the city of Marathon has a marina, because maybe they make some money off it, Monroe County can levy an ad valorem tax on that property. Bonds, important, another very important area.
So, Professor, just to sum up what you just said, so properties that municipalities own, they're exempted, they don't pay taxes?
No. A county, one of the entities above, one of the local entities above, this really only applies to, only counties do this. A county may levy an ad valorem tax, on property, real property or tangible personal property owned by a municipality. Just like if it was owned by Mr. Minton, okay? Except it's owned by a municipality. Unless, as I read, the property is being used exclusively, not just partially, but exclusively by it for municipal or public purposes. The exclusivity would be the town hall, for sure, city hall. The parks, the city recreational areas, all of those things. But if the city of Marathon has a place, and on that little promontory, they have a marina that they operate, and anybody can come in and use it, which they do down there. Or let's say they lease out a piece of their property to the Chili's next door to the marina, so some people can eat, and they have their city hall on it. The county, because they're below the line. You remember my line? Where's number 8? They do not have the municipalities are corporations, corporate entities, government corporate entities. They're not sovereign. So the county can tax the municipality. And the question will become whether or not those 3 examples, they're used for municipal or public purposes, and so in those 3 examples, the city hall is certainly exempt, but the property under the Chili's is not exempt, nor is the marina property exempt. Yes, sir.
What about a city hall, large building, with a small for-profit restaurant?
Mr. Minton.
Sorry, but it says
Yeah,
exclusive.
you should be sorry. Exempt. Yeah.
Argue both ways.
Yeah, because it's all necessary to the municipal purpose. Exempt. That's my ruling. No. 30 days. Okay, this is important, as is everything else that I've tried to talk about today. Borrowing. This gets tested a lot. The additional way and the third way in which state and local governments borrow are found in Article 7, Sections 11 through 18. 1 through 9 is taxation. Article 7, Sections 1 through 9, taxation. Article 7, Sections 11 through 18, bonds. The law is, and again, now I'm looking, please turn to Article 7, Section 10, pledging credit. Neither the state nor any county, school district, municipality, or special district shall become a joint owner with or stockholder of or using its taxing or power or credit to aid any corporation, except for the issuance of, I'm down to C, revenue bonds. I'm going to explain what a revenue bond, an industrial revenue bond, that's C. I'm going to explain what that is momentarily. But getting up and looking down on the whole subject, the whole purpose of these 9 sections of the Florida Constitution is to limit the ability of the state and local government to tax. Your legislators and commissioners cannot go out and spend future money, okay, somebody else's money into the future. That's why these limits exist. I'm going to be very brief on the state side because I think it's the least important of the 3. The state can borrow money to finance the cost of fixed capital outlays upon approval of the electors, with some exceptions. So the state may pledge the full faith and credit of the state, all of the revenue that I've just talked about that goes into the general revenue fund, and borrow, but they may do it only under 2 conditions. 1, to finance the cost only of fixed capital outlays, buildings, roads, bridges, things of that nature. And if they do, it must be approved by the electors, by a vote of all the people in the state, by 50% or more, 51%. Why is that? So that, as I said, the state legislatures can't go up there and make everybody happy and then go home. And there are some limitations on all of that. They can also borrow without voter approval if the bonds are non-recourse bonds, meaning that they're not payable. Meaning, as I say in my class, the public fisc is not at risk. Public fisc is not at risk. The general revenue is not at stake. Somebody asked about a bridge. Money was borrowed for the St. Pete Bridge a couple times. And it was pledged, they borrowed the money, and what's pledged was all of the revenue you drop in to the bucket as you go across the bridge. The public fisc was not put at risk, only there. Local bonds, same concept, except instead of the state of Florida, we're talking here about counties, school districts, municipalities, and special districts. Local governments can also borrow, but if the monies they're borrowing is being secured by ad valorem taxes, that's their main pocket of money, right? We talked about that. Then they're limited to borrowing only for capital projects, capital outlay projects, what we've just talked about, and only by voter approval. If the public fisc is not at risk here, ad valorems taxes are not being not being put at risk. Let's say they build a bridge and finance it through, some counties have, Santa Rosa, I think, the money going into the meter, then they don't have to have a vote of the electors. This one, meaning general obligation, these two mirror each other, meaning these are general obligation bonds for the state, general obligation bonds for local government. Now I have to talk about the tricky one that gets tested. If things didn't get tested, I wouldn't bother. Industrial revenue bonds. Industrial revenue bonds, that's this column. Industrial revenue bonds would go back to Article 7, Section 10, which says that the state, neither state, county, school district, or other municipalities or special districts shall become a joint owner with or lend their tax and credit power to a local entity, a corporation, private entity, except C, 10C, the issuance and sale by any county, municipality, special district, or other local government body of revenue bonds to finance the cost of capital projects of various types. Here's the outline, okay, of that section, and then some. This applies only to local governments, only local governments. This is complicated and critical, folks. Local governments can issue a bond. They're the issuing entity. They're the borrowing entity for the purpose of building airports, industrial and manufacturing facilities, and other capital projects under certain conditions. With respect to industrial and manufacturing facilities, by virtue right of the text itself, I didn't read the whole thing, the bonds must be payable from the project and the interest must be federally exempt. What are these bonds used for? These are economic development bonds to allow the local governments in the state of Florida to compete with local governments elsewhere in the United States. If you've ever driven from Tallahassee over to Jacksonville on I-10, on the left-hand side as you go, you're going to see this huge Publix distribution facility. That facility was financed by industrial revenue bonds. The county that it is located in borrowed the money, knowing it was for a public purpose, a private purpose, which would ordinarily be prohibited because government's not supposed to loan money to private companies, at least in Florida. But there's this exception in 10C. This particular distribution operation was considered an industrial facility because all the food comes in and gets distributed out to the rest of the state. That county was in competition with a county up in Georgia. So the county offered the bonds, and they were issued, they were approved and issued. They met these conditions. They have to be federally exempt. And the bonds were payable by the Publix Corporation. Economic development bonds, that's what they are. They must meet the textual conditions of Article 7, Section 10C. That has been expanded by the Florida Supreme Court so that bonds can be also issued for other capital projects, things that are not necessarily, that are not industrial or manufacturing in nature. Think about an insurance company. That's not a headquarters of an insurance company in Orlando, a real case. It's not industrial. It's hard to say that it's manufacturing. But if it meets the same conditions or similar conditions, the project is a public purpose and bringing 1,000 new jobs in is a public purpose, and the interest on the bonds are federally exempt, Orlando could borrow them, and the money goes just as I said. If there's going to be any little bit of public funds behind the bonds, then there's a higher standard of public purpose. It is important to recognize that. Homestead. Homestead. Article 10, Section 4. Homestead, the homestead exemption. There are 3 sections to it. Article 7, Section 4, A, B, and C. And it has the provision has 4 purposes. Of course, it's tested. I'm sure you all know that. Article 7, Section 4A, the first one, provided there on my, I hope you have it in front of you. A provides an exemption from creditors' claims, a lifetime exemption to the owner of the homestead from creditors' claims. For B, the next one down, continues the protection to a spouse or heir with respect to those creditor claims, and only those creditor claims. The claims against the decedent. I'm going to get more detail. C is a limitation on devise, something different. And what it says is that there's a limitation on devise if the decedent is survived by a spouse and minor child. And if so, the property cannot be devised, and it proceeds under the laws, a special law of intestacy. The last one's easy. Restriction on alienation. A married couple, with respect to a married couple, in order to sell the house, sell the homestead, or sell a homestead or mortgage it, in order for that sale or mortgage to be valid, the spouse must join in the conveyance or mortgage. Let's go to the provision, the text. (4A). These operate to a large extent independently, but not solely. Says, there shall be exempt from forced sale. That means you can't get a lien, the creditor can't come and get your property or put a lien on it. There shall be exempt from forced sale with certain exceptions that are laid out there in bold. The following property owned by a natural person. What are those exceptions? They are the exceptions that you would expect. Exceptions for taxes and mortgages, or if somebody comes out and puts labor and material into your property. Those types of things, obviously, particularly taxes and mortgages, you know, nobody'd give you a mortgage if you were exempt. If you could refuse to pay it and not be foreclosed on. So there shall be exempt from forced sale with the types of exceptions I mentioned. The following property owned by a natural person, a homestead outside a municipality of 160 acres of land, within a municipality of a half acre of land, importantly, although not bolded, upon which the exemption shall be limited to the residence of the owner's family. In addition, for that same homesteader, while he's alive or she's alive, there will be an exemption for up to $1,000 of personal property in the house. That's what I describe as the lifetime exemption of the owner of the house from creditor's claims, whether that be a single owner or a married couple. Okay, a judgment against a married couple. Lifetime exemption. They have a lifetime exemption so long as the property is homestead property. When a person dies, when somebody dies, and I now want to think of just a single owner, okay? If in a single owner situation, when somebody dies, B comes into effect. The exemption shall inure to the surviving spouse or heirs of the owner. Heirs of the owner are any heirs as defined by the Florida statutes, section 432.103 or 2 or 3. It's in your materials. Then we get down to C, as I said. C, the homestead shall not be subjectivized if the owner is survived by a spouse or minor child. Let's work through these. First, what type of property can qualify? Just again reading text. In A, it's a homestead. And if you read it, it can't be anything other than real property and personal property. What is a homestead? What's the definition? What must the owner, the individual who owns that property, Mr. Jones, let us say, owns that property, he gets a judgment against him. There's a judgment, the credit MasterCard gets a $50,000 judgment against him, and they come out to execute, and he says, no, hold up, you can't do that, my property is homestead. It then becomes his obligation to go in court and prove that, and he must prove, and again, this is almost all out of the text that I just read you, that he is a natural person. The corporation doesn't get homestead. However, if he owns that property in trust, in irrevocable trust, he does. In irrevocable trust. Not quite so sure for irrevocable, but certainly an irrevocable trust, just as if he owned it himself. So he must prove that it's owned by a natural person. He must prove that either he is making the property his home or he intends to make the real property his permanent residence, as the word goes, or that the $1,000 of property is in the house. And the last thing he must prove is that the property meets the size and contiguity requirements of Article 10, Section 4A. They are laid out there, 160 acres of land, contiguous land outside a municipality, half acre inside a municipality. With respect to the outside of municipality property, 160, if some of it gets wrapped up into a municipality, it still remains exempt. Inside a municipality, notice, as I said, that it's only the portion used as a residence. So if you have a half acre and using half of it as residence, 1/4 acre is your residence, and another 1/4 acre you have a plant sales stand or something like that on it. Only 1/4 acre is exempt. This is another thing I'd go to the rafters for. The exemption, Mr. Jones's exemption, ends under 3 conditions, the first of which is the important one, upon his death. Okay, because he's got to have it as permanent residence. If he abandons it, obviously he ends it. If he sells it, ends it. Upon death, upon his death, the exemption he had Only those creditors, not his credit, not some new person's creditors, but the debts that he had, that the judgments against him. The homestead character of the property ends. This is critical. Ends. But the creditors of the decedent, Mr. Jones, still can't execute on the property. The creditors, and the property will go off to somebody else, like a spouse or heirs or something like that. And the creditors of the surviving spouse or heirs let me get this right. The property, the creditors cannot come over against spouse or heirs to whom the property is conveyed. Okay? And with respect to the spouse or heirs who remain on the property or come to the property, their debts, if provided as homestead property, in them, their creditors cannot execute on the property. Let me say that again. When a homeowner dies, okay, the owner of the property dies, he's got a $50,000 judgment against him. That property somehow or another is going to be conveyed to somebody else, whether it be by intestacy or not. If it is conveyed to a surviving spouse or an heir, then an heir is defined. Then the creditor here cannot collect on the property. However, the creditors of the surviving spouse or heir can collect on the property for any judgments against them unless the spouse or heir makes that property his or her own homestead. If the spouse is living off-site, say, she's got to come on site. Or the heir could be a niece, nephew, any of that, doesn't have to be the next one in line. Same thing. What is an heir? An heir is defined in that section. That's who usually gets stuck, meaning judgment creditors don't get their money, and personal representatives can't bring property into the estate because it passes outside the estate to the spouse or heir. 4C. Did you have a question?
I have two questions. If an heir comes into possession of the property, do they have a good faith opportunity to move on or move to the homestead and make it their, or if they're not there when the person dies, they can't dilly dally away.
They cannot.
Creditors coming after me.
That's right.
You know what I mean?
I think I do know what you mean.
So if they make a good faith effort to move on to the property and make it their permanent residence.
That's right. In order for that property to be exempt in them, it's the same as when the decedent made it his homestead. Either the spouse, for example, either has to be there already, or if it's an estranged spouse, because it doesn't matter whether it's estranged or not, the law applies. With respect to the judgments against the estranged spouse, you know, a $30,000 visa judgment against her, say, if she intends to make that her homestead, because that's one of the two reasons, then she would not. Then the property would be exempt from the creditors of the decedent and the creditors of the spouse. Am I making sense?
Yes. Yeah, but then she just has to make a good faith.
She has to intend to make it her. The guy dies, they hated each other. Next day she intends to make it her house, her place.
Second question is the ceiling
It's a, yes, I didn't say that, but
Beneficiary or a trustee who lives in the property could make it the.
no, not a trustee. The ownership interest does not need to be a fee simple interest. The ownership interest by the decedent or anybody who subsequently comes into possession of the property. The property must be a possessory interest. It can be fee simple. It can be a life estate. But it cannot be a tenant. It does not apply to a tenant, okay? And, pardon? Or a remainder interest. That's not a possessory interest. Okay, now I need to say a word about, this is complicated, more complicated looking than it really is. They're all your statutes, by the way. And I handed out some new statutes because they've been updated, so you can use those. If that property is owned, if at the time Mr. Jones dies, he has, now the one I want to call your attention to is 732.401, the most critical statute in your packet of statutes, okay? When Mr. Jones dies, if he is survived by a spouse and minor child, that under Article 7, Section 4C, he cannot, Mr. Jones cannot, he has no legal ability to devise the property to anybody, period. His friend, girlfriend, anything. The property passes as in intestacy. 732.401 says, if not devised as authorized by law and the Constitution, which by definition, as I said, it's not, the homestead shall defend in the same manner as other intestate property. But if the decedent is survived by a spouse and one or more descendants, the surviving spouse shall take a life estate in the homestead with a vested remainder to the descendants in being, not just the decedent's minor children, descendants in being at the time of his death. And that's defined to include, what you'd expect, children, grandchildren, that sort of thing. So that's the first point. However, recently, and this is critical to know, number 2, in lieu of a life estate, the surviving spouse may elect to take an undivided 1/2 interest in that homestead, because life estates are often not worth having, with the other 1/2 divided among the descendants in being at the time of death. So if there are 3, and again, this is adult children, minor children, grandchildren, whatever you have. Those 2 provisions have been in the law for quite a while. We have 3 minutes, maybe 8 minutes, because I've ordered the clock back, to talk about Article 1. I'll leave that to the end because, like all of the rest of it, there's a substantial amount of Article 1 that is not derivable from the Florida Constitution. I'm going to work on the important ones, okay? The important ones, right there. So open your books, open your papers to Article 1 in the Constitution and move to that point of the, please, of the Constitution, of the overheads. First, one to know about is Article 1, Section 2. I bolded it up to make it pretty understandable, easily understandable. The basic rights principle, all natural persons are equal before the law. That's the Florida Equal Protection Clause. And they have the right, number 2, second right. There are 3 of them in this Article 1. In Article 1, Section 2, there are 3 rights. Equal protection, the right to acquire, possess, and protect and own and dispose of private property rights. And then the third one, the Fundamental Rights Clause, no person shall be deprived of any right because of race, religion, national origin, or physical disability. Note, sex is not in there for some historical reasons that I will not take the time to explain. This provision is applicable only in the context of the state government. In other words, there must be state action involved. If it only applies, Article 1, Section 2 can only be utilized to sue the state to seek an injunction against, let's say, discrimination on the basis of race, if it is the state that is doing it. There are other statutes and so on, federal and state, that apply if there's private discrimination for race, religion, physical ability, and sexual discrimination for that matter. So there must be state action for any of these 3 to come into play. State must be taking your property, not your next door neighbor, and the Equal Protection Clause similarly. There are levels of scrutiny that should be somewhat familiar to you. With respect to fundamental personal rights, the ones I noted at the third one above, strict scrutiny applies to fundamental personal rights. And I'm speaking here about personal rights, not just any old right that you might think you have, access to courts, for example. And right to privacy, fundamental personal rights. The way I analyze these, when I have a case, I start again at the bottom, just like I said earlier for the other subject. And I work up. If strict scrutiny doesn't apply, go to the next one and see if heightened scrutiny applies. If heightened scrutiny, with respect to heightened scrutiny, the test, the test is whether there's a substantial government interest, not quite as precise as the strict scrutiny. Doesn't usually apply in Florida. Commercial speech and school conduct. Schools have more ability to take care of kids, dress codes and that sort of stuff. If neither of those apply, then rational basis scrutiny applies, and that's the ordinary one that all the government has to do is come up with an idea as to why the statute exists. It doesn't even have to be a real idea. It doesn't even have to be an idea they had when they passed the law, as long as they can do it. So those apply in this state because equal protection is primarily an economic matter of economics. The rational basis test usually applies. A couple more that I want to hit here. Access to courts. This is critical. There's the provision, Article 1, Section 21 in your materials. The test is at the top of the next slide. When or where there has been a right to access the courts for redress of a particular injury, where that has been provided by either statutory law, predating the adoption of the Declaration of Rights of the Florida Constitution. That's predating the 1968 Constitution, by the way, the one we have today. or where the right has become part of the common law by virtue of this statute that started us all off in Florida. You had to start somewhere, so 2.01 brought in the common law of England into our state, and then there were statutes, of course, on top of that. But where a right of access existed under statutory law predating the 1968 Declaration of Rights, or were part of the common law, torts, contracts, things like that, the legislature may not abolish that right unless it either provides a reasonable alternative or demonstrates an overpowering necessity for the abolition of that right. Application. Workers' compensation. There was a law passed before World War II, exists today. And that law was passed upon the notion that we're going to abolish torts cases against employers. Torts cases against employers, of course, existed all the way back to England. So if you look at the test, it was part of the statutory law, or excuse me, it was part of the common law, I should say, pursuant to Section 2.01. It was brought over from England. Accordingly, under Article 1, Section 21, the state could not abolish that and put in workers' comp, which means you just get a chunk of money depending on what happened to you, unless they provided a reasonable alternative or met Condition 2. What they do, they provided a reasonable alternative. The Florida Supreme Court found fast, efficient, and proper, and therefore there was no violation of access to courts. If you're hurt on the job, you cannot sue your employer because you have a reasonable alternative. The number 2 example is med-mal. In med-mal, even if you don't know you were hurt, after 7 years, you don't get to sue. And the reason for that is, according to the legislature, there was an overriding power of necessity because otherwise doctors would leave the state. The next one that is critical is Article 1, Section 3, privacy. Every person has a right to privacy. This, as I said earlier, is a strict scrutiny matter, and therefore the government has to meet the compelling state interest test, of which you are well aware. It only applies to government action and only applies to reasonable expectations of privacy. And that is defined. First, there must be a reasonable expectation, and if the answer to that is yes, then the burden shifts to the state to prove that they have a compelling state interest through the least restrictive means. The next one, and the Winfield case actually explains that reasonably well. Administrative penalties. This is the sleeper. It has been tested once. And there is your test. And down at the bottom, begin for separation of powers principles, that administrative agencies cannot, state administrative agencies cannot award damages, compensatory punitive, attorney's fees, and cannot make criminal adjudications. They can levy fines and cease and desist orders. That is worth knowing. Think separation of powers and what the purpose is, and there's a case. These I'll mention. Florida has a right to work law. There's a right to work. Anytime you see in a question that something to the effect that the contract between the owner and builder requires union help or non-union help, anything like that, your antennae should go up. And the right to work, there has to be a right to work. You cannot force union or non-union, I should say membership in a union, membership in the union. Due process, we have procedural due process, substantive due process, and so substantive due process does exist in this state, and C is the critical point there. The test for substantive due process, again, arising in economic standards to the most part, but there's some examples given, is a rational basis type test. Procedural due process is what you might think it is. Search and seizures, the last one on the list, is there only because, first of all, search and seizure cases are gazillions a day. And with respect to Florida, our Constitution says you interpret it according to the United States Constitution, and there's the test number 1 right there, the provision. Anytime the United States Supreme Court has issued a case on search and seizure, that case binds the Florida courts. If they haven't, if the Supreme Court has not issued such a case and it's only the United States Supreme Court, then the state courts are free to interpret the provision however they wish. With that, we have now taken a tour of the Florida Constitution, and I'm sure that you all will be well prepared. Thank you for your attention.
Thank you.
Yes, lesson D, thank Judge Shepherd for, the last page is the best page.
Oh, the puppy dog. Yeah, my dog. My dog, Tulip. Yes, there she is.